My name is Patrick Kitchin, and I'd like to talk with you about how lawsuits are filed, prosecuted, and resolved through settlement or trial. Most people who are unfamiliar with the litigation process are surprised at how long it can take to resolve a lawsuit. Even a simple case can sometimes take a year or more to move through the courts. The good news is that only a small percentage of cases filed in court ever go to trial. Most are resolved through settlement, sometimes within a matter of a few months. That's good news for an injured person who has medical bills and lost income and who would rather put an injury-causing incident behind them. A lawsuit can be settled at any time, but generally not before lots of information has been exchanged between the parties to the lawsuit, and that takes time and work. When a person has a claim for damages, he or she has a legal right to file a lawsuit in court against the person or the company that caused the damage. A person who is injured and who seeks recovery through the civil justice system is called a plaintiff. The person or the company that has injured another is called the defendant. Every claim made by an injured person is set out in a complaint, a document that describes and summarizes the plaintiff's claims. Each separate claim in the complaint is called a cause of action, and it must be based on the law applicable to the plaintiff's claim. Different causes of action have different proof requirements that the plaintiff must carry or prove to obtain a judgment against the defendant. So let's talk about a typical negligence case, how it is prosecuted and how it is resolved. A young man was walking across the street when he was hit by a car. The driver of the car was distracted for a moment and didn't see him in the crosswalk. He was thrown to the pavement and suffered a broken leg, cuts, and scrapes. During his recovery, he comes to us for help. We first prepare a complaint against the driver, setting out all of the elements of a cause of action for negligence, and then file it in court. We then serve the complaint on the driver, the defendant. The defendant has 30 days to file an answer to the complaint. During the next 4 to 8 months, we investigate the facts of the case and participate in formal discovery. In every civil lawsuit, the plaintiff and the defendant have the right to obtain written responses to questions from the other side. The parties also have the right to demand that the other side produce relevant documents. The discovery phase can last several months, depending on the number of witnesses and the complexity of the factual and legal issues at stake in the case. Toward the end of the discovery phase of the case, the plaintiff and the defendant will provide one another with the names of the persons they intend to use as expert witnesses. We typically designate our clients treating doctors and therapists. The defendant's lawyers usually designate one or more doctors who make their living working as expert witnesses in personal injury cases. Both sides now take the depositions of the designated expert witnesses during what is called the expert discovery phase of the case. If the case has not been resolved through settlement negotiations, the case will move toward trial. Trial is normally scheduled to occur within 1 year of the date the plaintiff filed his complaint. Throughout the course of the lawsuit, the attorneys regularly meet with the judge to update her on the progress. The judge usually orders the plaintiff and defendant to try to resolve the case through a process called Alternative Dispute Resolution, or ADR. ADR can be in the form of mediation or arbitration. Mediation is conducted by a retired judge or an experienced attorney. The parties meet with the mediator and spend time trying to resolve the case through negotiations. The mediator does not order the parties to settle the case, but works with them to see if they can settle the case on terms that work for both sides of the dispute. Arbitration, another form of ADR, is kind of like a trial without a jury. A retired judge or an experienced attorney hears the parties' evidence and at the end of the arbitration issues a ruling either in favor of the plaintiff or in favor of the defendant. In most personal injury cases, both parties have the right to reject the arbitrator's decision and proceed to trial in court. As you can see, the litigation process is highly organized and proceeds through its various stages at the pace set by the rules and the procedures of the court. While the slow pace of the litigation process can sometimes be frustrating, our goal at Kitchin Legal is to educate our clients about the litigation process so they can be active and knowledgeable participants in their own case. If you have any questions about the litigation process, please give me a call.